Maternity leave is not just a privilege, it is not a privilege. Background of this case is that there is a lady named K. Umadevi. K. Umadevi was an English teacher in the government of Tamil Nadu. She was a married woman and she had 2 children. But in 2017, unfortunately, she got divorced. If a lady has more than 2 children, then she will not get the benefits of maternity leave. The act is there, but its implementations are very poor. Hello everyone, welcome to Ajmal Academy. Today we are going to discuss a very important Supreme Court judgment that has been recently given by Honorable Supreme Court in the month of May 2025. Before proceeding in the class, I'll give you the crux of this case because it is going to be very important for your upcoming UPSC mains as well as APSC mains. Okay, what Supreme Court had held that? Supreme Court held that maternity leave is not a privilege; it is a fundamental right under Article 21. The official name of the case is that K. Umadevi versus Government of Tamil Nadu 2025. It is a benchmark case which deals with the dispute between the service rules and constitutional mandate. Okay, so this is the crux of this case. I have given you the crux. Now let us go into the deep into that case, and I'll give you the background of it. I'll give you the statutory provisions which are related with maternity benefits, and we are going to discuss one UPSC PYQ which has been came in 2019, and I'll also give you a mains practice question which you need to write. Okay, so let's deep dive. Okay, now background of this case is that there is a lady named K. Umadevi. K. Umadevi was an English teacher in the government of Tamil Nadu. She was a married woman and she had 2 children. But in 2017, unfortunately, she got divorced and she did not get any custody, any of her child. Okay, she did not get the custody of any of her child. And in 2018, she remarried. In 2021, she got pregnant. And because of her pregnancy, she applied for maternity leave. But interestingly, the Tamil Nadu government has rejected this leave, citing that this is violating the fundamental rule 101 clause A. What does clause say? That if a lady has more than 2 children, then she will not get the benefits of maternity leave. Okay, and because of that rule, the maternity leave application was rejected. And because of that thing, Umadevi reached Madras High Court. She applied for it, and a single bench judge given the judgment in favor of K. Umadevi, citing that since the other 2 child is not with K. Umadevi, that's why she should get maternity leave for the newborn child. Okay, but Tamil Nadu government again filed a review petition, and this time the division bench of the Madras High Court reviewed its own judgment. Okay, and this time they have given the judgment in favor of Tamil Nadu government, citing that the new child is the 3rd child. And according to the fundamental rule 101 subclause A, means it is the service rule of Tamil Nadu government, which states that a lady cannot have maternity leave if she has more than 2 children. Okay, so because there is no option for Umadevi, that's why she have to reach to Supreme Court. And Supreme Court, she filed a petition regarding this dispute, and Supreme Court held that maternity benefits, maternity leave is not just a privilege, it is not a privilege, it is a fundamental right under Article 21. That is the crux of this case. Now we are going to discuss what are the justifications that has given by the Supreme Court, because these justifications you can use in your mains, you can use in various topics related with the maternity benefits. Okay, see what Supreme Court has given the justification is that why they have put maternity benefit under Article 21. Article 21 talks about right to life and personal liberty, but here right to life does not mean mere existence. It talks about human dignity. It talks about life with dignity. And maternity benefits, maternity leave is a part of women dignity. It is essential for women dignity. And because of that thing, maternity leave becomes part of Article 21, which is a fundamental right. So the crux of this case is that Supreme Court said that Article 21 also include maternity relief. Okay, so since it has been delivered recently in May 2025, that because of that thing, this topic become very important for your upcoming mains. Okay, what are the other justifications given by the Supreme Court? Other justification is that there is an Article 42 in the DPSP. DPSP, Directive Principles of State Policy, which talks about maternity benefit. Okay, but at the same time, Supreme Court said that there is an importance of population policy and family planning, but at what cost? The cost should not be violating the dignity of women. Okay, so family planning should be there, population policy should be there, but not violating dignity of an woman or dignity of a person. So these are the some justifications given by the Supreme Court, as well as there is a statutory provision. There is a central law, which is the Maternity Benefit Amendment Act of 2017. According to this act, a lady will get maternity leave of 26 weeks for the first two child, and from the third child onward, she will get the benefit of 12 weeks. Okay, and there's a section which talks about if there is a confusion between the central law and state law. In this case, the Tamil Nadu government, the state law talks about, I have told you about now that 101 subclause A, which talks about that maternity benefit cannot be given to a lady who has more than two child. But here in the central law, Maternity Benefit Amendment Act of 2017, it talks about that maternity benefit can be given to a lady of more than two child, but she will get a benefit of 12 weeks, not 26 weeks. Okay, and the section says that when there is a confusion between the central law and the state law, the central law prevails, and from this angle also she should get the benefits. So because of these things, because of these justifications and the judgment that is given by the Supreme Court directed Tamil Nadu government to grant the petition, grant the maternity leave petition, and also compensate K. Umadevi. So this is the whole scenario, this is the whole case. Okay, now we are going to discuss one important statutory provision, that is the Maternity Benefit Amendment Act of 2017. Okay, this become very important because of this judgment. A question might be come on this, so that's why we are going to discuss it. See, Maternity Benefit Amendment Act 2017. Earlier it was an act of 1961 where maternity leave were for 12 weeks. Now it has been increased from 12 weeks to 26 weeks, but only for two childs. Okay, means a lady will get the maternity leave of 26 weeks for her two childs, and from the third child onward, she will get maternity benefit of 12 weeks. Okay, that is one point. Second point is that this act also included those mothers who become mother by adopting a child or surrogatory mother. They will get maternity leave of 12 weeks. Okay, there is another provision is that work from home option, means after the maternity leave has been over, the employee can reach to the employer, and there might be some mutual conversation. If the job is of nature of work from home, then she could be allowed by the employer to work from home. So that is a provision is there, but it is not mandatory that she should get the work from home provision. It is depends on the employer also. Okay, then there's crash facility option is also there, means this act is been first I'll give you one point. Another point is that this act is applicable to those organizations which have number of employees of 10 or more than 10. Means the Maternity Benefit Amendment Act will be applicable to all those institutions, all those organizations who have employee number of 10 or more than 10. Okay, so all the employees of those organizations will have to or will get the benefit of this benefit of this act. Okay, but there's a crash facility. I have talked about the crash facility. What about the crash facility? The crash facility option is only for an organization who has employee of more than 50 or more than 50. Means if an institution has number of employees of 50 or more than 50, then there should be a crash facility for the babies. Okay, and mother should be allowed to visit the crash daily 4 times, including the break time. Okay, so these are the provisions which is given in the Maternity Benefit Amendment Act of 2017. So there is also a point that it should, in this act, protect the lady from dismissal. मतलब ऐसा हो गया कि मतलब वो maternity leave में है और पीछे से employer ने मतलब उसको dismiss कर दिया, ऐसा तो नहीं होना चाहिए, है कि नहीं? तो she has the protection from dismissal during this leave period. So she should not be dismissed. So these are the some provisions that has given in the Maternity Benefit Amendment Act of 2017. But since this seems to be very true, this seems to be very good, but there are challenges regarding this act. because it seemed to be very good, but in practicality, it has some kind of challenges. One challenge is that from the point of view of the employer, if you are an employer, means if you are an owner of the organization, would you like to hire a woman candidate? Because if you hire a woman candidate and if she got pregnant, then you have to bear the whole cost, and as well as you have to give her the maternity leave of 26 weeks. And during this period, you have to pay the whole salary to the woman. And to replace her or to replicate her job or to compensate her job, you have to employ some another person, and you have to pay that person also. Because in this act, there is no cost sharing provision. मतलब ऐसा नहीं बोला कि गवर्नमेंट आधा लेगा कॉस्ट और मतलब एम्प्लॉयर आधा लेगा, ऐसा नहीं बोला है. पूरा कॉस्ट किसको मतलब लेना पड़ेगा? Who will borne the whole cost? It will be the employer. So it actually discourages the employer to hire women. So that's become very discriminatory for the women. It is against the economic justice of women. It is violating SDG 5, that is gender equality, isn't it? So these kind of challenges are there. Okay, and also one data says that after 2017, actually in the IT companies, they have reduced their hiring of women employees because of this thing. Okay, so this is one of the challenge. Then another challenge is that there's a discrimination in the hiring as well as cost bearing issue is there. Then another issue is that there is no provision for the paternity leave. There is no provision for paternity leave. Like the maternity leave is there is no provision for the paternity leave. Means the shared responsibility, the concept of shared responsibility is not been promoted by this act. And it is indirectly saying that to giving care a child, okay, the responsibility of mother lies to care, giving care to the child. It is not the responsibility of the father. So that is one of the biggest challenges, because we are promoting gender equality. We are promoting that the responsibility to take care of the child is responsibility of the both mother and father. But this statutory provision is not providing the same. Okay. Then we can say there is one more challenge which is related with every scheme, every program of the government, is that poor awareness. Because most of the organizations or most of the women are in the unorganized sector. Though this act covers both organized, unorganized sector, means private sector as well as public sector, organized and unorganized sector. But the issue is that the women are not aware about this act. And also in the unorganized sector, there is no contract between the employer and employee. If a woman gets pregnant in unorganized sector, if she requested for maternity leave, the employer will say, you do not work here, why should I give you the leave? Why should I give you the payment for 26 weeks? And because of that thing, the woman did not get the benefit of this act. Because there is lack of implementation, lack of awareness. So that's a big issue. And most of our women are work in unorganized sector. More than around 90% of the women are work in the unorganized sector. So that's a big issue. See, the act is there, but its implementations are very poor. So we can see some solutions also. We can see there are some way forward also. One way forward is that I have already told you, shared responsibility, that there should be paternal, like maternal leave, there should be paternal leave also there. Paternity leave also be there. Now it is only for applicable for the central employees. 15 days paternity leave is there, but it is not applicable to everyone. Okay. Another one is that there should be financial support, means the cost should be bared by both the government as well as the employer, or government can give some kind of incentives to the employer that, wow, you have given the maternity leave, these are the incentives you can enjoy. So these are the some kind of solutions that you can promote, that you can write in your answer. Okay. And another one is that there need to be awareness. There should be awareness programs by using the ASHA workers or the local NGOs. Okay, the implementation should be good, because statutory provision is there, but its implementation is very poor. So this is a mains question regarding this whole topic, that maternity benefit is not a privilege but a constitutional right under Article 21. Critically examine the effectiveness of the Maternity Benefit Amendment Act 2017 in securing this right for working women in India. Okay, please try to write this answer. Okay, and at this point of time, I will give you one information that you can have this whole PDF from our Telegram channel. The link of this Telegram channel is given in the description below. You can join the Telegram channel, you can download the PDF, okay, and you will get the whole topic, and you will get some kind of contents regarding this topic. Okay, now just pause your video and try to attempt this question. This question has come in UPSC prelims 2019. Try to pause this, just pause the video and try to attempt. Okay, hope you have attempted the question. This question, what does the question talks about? Option 1 is that pregnant women are entitled for 3 months pre-delivery and 3 months post-delivery paid leave. Statement 2, enterprise with crash facilities must allow mother minimum 6 crash visits. Women with 2 or more children get reduced entitlement. C. In the statement 1, that there should be 3 months pre-delivery and 3 months post-delivery paid leave. It is not like that. It is the 8 weeks, not 3 months. So statement 1 is incorrect. So if statement 1 is incorrect, then A and D will be cut down. 2 and 3 and 3 only. What is 2 talks about? Crash facilities must allow minimum 6 visits. I have already told you it is not 6 visits, it is the 4 visits. So statement 2 is also incorrect. So option 3 is the correct answer. Okay. Here is the explanation. I will also given the explanation. Option 3 is the only correct answer. Means option C will be the correct answer. So this is the crux of this whole session. Hope you have liked the session. Thank you.